Our View with John Anderson.
Do we really need to put a referendum on the ballot to determine how we feel about medical marijuana on Guam? Well, apparently so, since our legislature went to the trouble of getting a declarative judgment from the Supreme Court on putting just such an act on the November ballot. The Guam Supreme Court said the question could be offered to the voters. Confronted by this legal decision, the Guam Election Commission has unanimously approved the action to push the question of legalizing medical marijuana, at least the medical use of it, if not the recreational use, on the November 4th general election ballot. So, registered voters will have a chance to weigh in on this question. It will give voters the opportunity to consider the Joaquin K.C. Concepcion Compassionate Cannabis Use Act of 2013. We spoke with attorney and former Senator Howard Trapp, who said the act will be part of the November 4th general election and will be subject to the Santos Amendment, meaning blank ballots will be considered as no votes. The measure must be approved by 50% plus one of all votes cast in order to become law. If Guam voters support the act in sufficient numbers, there still may be an issue of federal law with which the referendum may be in conflict. As currently interpreted, Guam may not pass any law which conflicts with a federal statute. That's in the Organic Act. In this respect, Guam, as a federal possession, may lack the authority to make a marijuana referendum part of the local law if it conflicts with federal law, even if federal marijuana statutes are not being enforced presently. It makes the November 4th general election just a little bit more interesting.
Our View represents the editorial opinion of the Pacific News Center.